Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 242 of the NCDWI Guy podcast. On today's episode, we are talking about challenging speed in a DWI case. Take a step back. How many of your DWI clients, when they call in, you start the consultation with them, how many of them tell you, I was pulled over for speeding, and then off we went towards the DWI investigation? A lot. Speeding stops are the basis of a high percentage of DWI arrests. And yet, how often in the courtroom do you see the speed challenged? How often in the courtroom do you see an attorney questioning the officer on whether or not they visually estimated speed correctly, on whether the results of their radar or speed measuring device should be allowed into evidence? Is there a sufficient basis, a sufficient foundation for the radar results to be admitted into evidence? This is something that I think that DWI attorneys across the state are frequently leaving on the table. And let me speak to the doubters for a second, and I will include myself in this because it is not a typical thing to see speeding tickets challenged. You don't see that a lot. It's not a typical thing to see the basis of the stop, where the stop is speeding, challenged in a DWI or other traffic related case. You just don't see that challenged often. And even if you don't anticipate that the results of attacking the speed are going to lead to the case being thrown out, I urge you to learn this stuff, to fight on these issues, and to push the agenda, push the officers to the limit, put their feet to the fire. And here's the reason why. If you get an officer on the stand and you get him uncomfortable testifying about how he visually estimated speed, if he wasn't a certified operator of the Golden Eagle or whatever radar device he was using, if he didn't calibrate it correctly, if he wasn't sure when it was last calibrated, there are so many ways that you can start to chip away at the officer's testimony through that basis for the stop. If you just concede the stop and you say, okay, the stop was legit, but now we're challenging probable cause. If the officer didn't know what he or she was doing when they initiated the stop based on speeding, and you can bring that out, you are leaving a lot on the table, even if the judge disagrees with you on that issue, finds that the stop was valid, because now as that plays into probable cause and into the officer's credibility as to the other bases for his or her probable cause, now you have created doubts in the mind of the judge about whether or not this officer knows what they are doing. Don't leave these issues on the table simply because you don't think that it is going to result automatically in your case getting thrown out. You never know what might happen until you try it. And if you've got a good issue otherwise, this is a great place to give it a whirl, because you then have nothing to lose by adding this issue in. So a couple of things that we're going to do today. We are going to take a look briefly at State versus Vaughn, which is a newly published opinion from the North Carolina Court of Appeals. it was filed on December the 3rd of 2024. A lot of great DWI issues in Vaughn. The appellate defender or the appellate attorney that represented the defendant in this case was Les Robinson out of Greenville. And I know that Les gave him hell on this case because he always does. He is an absolute warrior in the courtroom. And so I know that these issues were well battled. I couldn't tell from the opinion if he also represented the defendant in trial court. But in terms of the appeal, that is the listed appellate attorney. And again, know that Les was working hard to get this case righted. But we're going to look a little bit at State versus Vaughn, and then I want to share with you an amazing CLE that we are offering on this specific topic, March 7th in Raleigh at the Campbell School of Law. We're going to use one of their state-of-the-art courtrooms. It's going to be an amazing CLE, so I'm going to share some details with you on that front. But to dive into State versus Vaughn, this is a case where one of the issues presented by the defense was the radar foundation. And so the defendant basically said that there was not sufficient foundation for the officer to have basically introduced the results of his speed measuring device. So this is coming straight from the opinion. Defendant posits that the trial court committed error by admitting the radar numerical reading because the state failed to elicit the exact name of the agency that approved the radar model, issued the operator certificate, and inspected the device. So that is kind of the main challenge on this point. Ultimately, the Court of Appeals rules against the defendant on this issue and on the other issues presented in the opinion. But what Vaughn does is a great job of a kind of 30,000-foot overview of the law of speeding in terms of when is a radar device, a speed measurement device, to be used, when is it allowed into evidence, what is the statutory and North Carolina Administrative Code framework for speed measuring devices. And so it's a great place to kind of sink your teeth in if you are new to this issue. There is great references to kind of the big cases on this topic, great references to the statutory framework, great references to the North Carolina Administrative Code, as well as to the publication by the North Carolina Academy of Justice about basically the radar operator manual that is issued to officers through the academy. So just a great case and statutory framework for this type of issue. One of the things that Vaughn points out, which is nothing new, but again, it's front and center. And I think it's something that we typically forget about in these kind of cases, is that radar results under NCGS 8-50.2 are for the purpose of corroborating an opinion about speed. So speed measuring devices, radar devices, somebody's speed captured on radar. The only reason it is allowed into evidence is to corroborate an officer's visual estimation of speed. If the officer did not do a visual estimation of speed, the radar results should not come in. If the officer doesn't know how to visually estimate speed, did a bad visual estimation of speed, the radar results, which are corroborating that crappy visual estimation, should be thrown out. So this is really important. You have to understand what is the purpose of the speed measuring device. 100% exclusively dependent on corroborating the visual estimation of speed from the officer. So if you are able to successfully call into question the officer's method for doing a visual speed estimation, his training for doing a visual speed estimation, then the speed measuring device, which is backing that visual estimation up, has no place in evidence. Then the court in Vaughn goes on to go through the North Carolina Administrative Code and North Carolina General Statute framework for how speed measuring devices are to be used, who is to be using them, how they are to be kept and maintained, how they are to be operated. All of those things, Vaughn goes through in a really powerful way, unpacking what that looks like. What does it look like to actually keep your speed measuring device properly maintained, to operate it properly, which speed measuring devices are approved? All of these things come into question. And now, where Vaughn falls a little short is that I think it's difficult for a lot of officers to articulate really what is required for proper foundation, because a lot of it is coming from, according to Vaughn, and in reality, a publication by the North Carolina Justice Academy on radar operation. A lot of it is coming from the training of the officers. And if you are a DWI practitioner, you're doing this regularly, one of the things that I constantly preach is that you need to go to a NHTSA 24-hour course so that you can soak in what the officers are going through when they are learning how to conduct field sobriety testing and what signs and clues of impairment they are looking for on a DWI investigation. Until I went to a NHTSA 24-hour course, I had no idea what I was looking for. I had no idea how to challenge an officer when it came to testimony on field sobriety testing, on probable cause, on what clues they were looking for during their investigation that justified their arrest. I was shooting in the dark. But once you have that class and framework and you say, oh, this is what they are supposed to do in order to conduct the SFSTs properly. This is the method and technique and standardized way that the system that they are supposed to be going through when they look at a DWI investigation. If you can't dive into that in a meaningful way, you can't successfully attack a DWI case. I think the same thing is true on speeding challenges. And it's why, to me, most of us, and I'm going to include myself in this, do not routinely challenge speed. Do not routinely call into question the results of a radar device. Do not call into question a DWI stop where the basis is speeding, because we don't understand how officers are trained to conduct visual estimations of speed and how they are trained to use their speed measuring devices. Think about how difficult it would be to challenge an officer on PC and to challenge the PBT coming into evidence if you had never been through a NHTSA class and you had no idea what the statutory and North Carolina Administrative Code framework was for the PBT. Be darn near impossible to challenge that. But if you have that framework and that reference point, you know what the issues are. So you have to dig into what officers are being trained on when they are trained to be radar operators. How are they trained to do speed measurement? How are they trained to use a radar? So This is the basis, and it was kind of just good timing because this CLE was already lined up. But this is a basis for a CLE that we are offering at Campbell Law School on March the 7th. It has been approved for 6 hours of CLE credit. And Doug Scott will be the primary presenter at the CLE, former DRE instructor, former first approved DRE in the state of North Carolina, has done trainings on speed, radar use. Doug is going to walk us through how officers are trained to estimate speed. He's also going to walk us through utilizing the radar operator manual. I will be giving a legal overview on speeding. What are the major statutory framework points? What are the major cases that you need to be aware of if you're trying to challenge a stop based on speeding in a DWI case? Stephen Thomas from Driving Defense Law will be talking about utilizing the NHTSA SFST manual in speeding cases. A couple of attorneys from our office, Amy Smith, who's here in Asheville, and Lance Williams, who is in our Gastonia office, are going to conduct 2 mock cross-examinations. 2 mock cross-examinations. Doug Scott is going to walk us through a defense expert voir dire. So how do you tender an expert as the defense on this type of issue? But we're going to have 2 cross-examinations of an officer using the techniques that Doug presents. Leah Schellberg, who is in Greensboro, is going to be sharing sentencing strategies for cases that involve a kind of cross-section of DWI and speeding. And then Alex Marshall out of Raleigh will be delivering kind of our closing keynote of the warrior mindset and why you should try hard cases. So don't miss out on this amazing CLE opportunity in Raleigh. The cost of the CLE is $250. Again, this is approved for 6 hours of general CLE credit. We have got Doug Scott coming in to be kind of the primary presenter on this, but a great lineup of speakers. And if you want to hit the ground running, we are now 3 months out from this CLE. Actually less than 3 months, 2.5 months out from March 7th. This is a Friday. It's going to be from 9 to 4 at the law school. If you want to hit the ground running, go and sign up today. Cost of the CLE again is $250 if you sign up before January 1st. So if you want to dive into the new year with your educational hat on, included in your ticket will be our networking event, driving, yes, with freedom fighters, which we are going to be doing at, I think it's called Golf Shack, basically the functional equivalent of Top Golf, but Golf Shack in Raleigh on Thursday the 6th. So if you live in the area, no sweat, you come out on Thursday and have a great time with us at the networking event on Thursday evening, and then get a great day of CLE in on Friday. If you are coming in and staying the night from out of town, great way to hit the ground running, coming to our Freedom Fighters networking event at the Golf Shack. So pumped to have this presented. Our entire team of attorneys is planning to be there on the 7th. This to me is going to be amazing content. It is something that I think we are really leaving on the table when it comes to defending DWIs. And I really hope to see you there on March the 7th. If you want to sign up, go to freedomfighters.law, freedomfighters.law. And if you go to the events tab, you will see a list of events in chronological order, upcoming events. We have about 12 events this year coming up, but in that will be the attacking speed in a DWI case CLE. I think it's the third or fourth event listed. Again, if you sign up before January 1st, not only do you get an amazing day of CLE on Friday, but you get a free pass to our networking event at the Golf Shack on Thursday evening. So hope to see many of you listeners there putting your work into action, learning together, growing together, having fun together, and building a true network of freedom fighters. We have strength in numbers. Let's come together and learn together. Look forward to speaking with you again next time.